So we're going to start off our AI kind of section of the morning with a wonderful expert from the Copyright Alliance. Kevin Madigan is the Senior Vice President of Policy and Government Affairs at the Copyright Alliance, and he's going to start us off with some litigation background. So he's going to do a round robin of what I believe is 34, maybe it's gone up in the last 24 hours, 34 cases about AI that are pending right now, just to lay that groundwork. And then we're going to go into a panel to talk about some legislative ideas. So with that, let me introduce Kevin Madigan.
Thank you, Linda. Get this back in here. So I want to first start by thanking Linda, David, Chris, and everyone at American University for inviting me to talk about these ongoing generative AI lawsuits and for hosting this symposium. So just a very quick note about the Copyright Alliance, since my boss is here and probably want me to do this. We are the unified voice of the copyright community, representing the interests of thousands of individual creators and organizations across a spectrum of copyright disciplines. You can check out our website at copyrightalliance.org. Membership is free for those who want to get access to our newsletters and materials. Okay, so a couple things to note about the cases I'm going to be discussing this morning. The first is that I'm going to be focusing on cases involving generative AI technologies, and not just any cases that involve copyright claims and AI issues, broadly speaking. So when I talk about generative AI or GAI, I'm talking about large language models, image generators, music generators, and generative motion picture models that have launched over the past 2 years or so. The other thing is that I'm only going to cover cases involving federal copyright law claims, infringement claims. You know, there are a lot of cases out there that involve a number of different combinations of state law claims like unjust enrichment or right of publicity claims. Today we're just going to cover copyright law claims cases. And lastly, I'll just be talking about cases in the United States. Because I've only got about 10 minutes, I'm going to try to get through everything but leave a minute or two at the end for any questions y'all may have. So there have been well over 30 cases filed over the past 2 to 3 years, but you may see slightly different numbers depending where you look because many infringement cases have been consolidated. So for example, there have been similar cases filed against the same AI companies in the same district courts that involve similar groups of plaintiffs. And so in those instances, 2 or sometimes 3 cases have been consolidated down into one case. I should also note, while I don't have time to discuss them today, there are 2 copyrightability cases against the Copyright Office. These cases were brought by people who tried to register works with the office but whose applications were denied because they either claimed an AI model as the author of the work itself, or the office found there wasn't sufficient human authorship to merit protection. So those are going to be interesting cases to follow. So the cases have been brought mostly in district courts all over the country, mostly in the Northern District of California and the Southern District of New York. But there are also cases in district courts in Delaware and Massachusetts. Another important point is that the cases mostly involve claims of direct copyright infringement for copying at the input or ingestion stage, and violations for the removal or alteration of copyright management information, CMI. Those are also known as 1202B claims. Many cases started out with claims related to infringing output or claims saying that the AI models themselves qualified as infringing derivative works, but those claims have largely been dismissed. So the overwhelming majority of cases filed have been brought by copyright owners of literary works. So we're talking about book authors, newspaper publishers, online news websites, against AI companies that they allege have scraped their works off the internet and used them without authorization to train their large language models. So, OpenAI's ChatGPT or Google's Bard. And a lot of the plaintiffs in these cases accuse the AI companies of using data sets for training that are known to contain large amounts of pirated literary works. So sometimes these are called shadow libraries. And a couple examples of those data sets are Books 3 and something called The Pile. Now, one of the stronger cases in this group involving literary works is the New York Times v. OpenAI. And I say that because the complaint includes examples of prompting ChatGPT to generate verbatim or near verbatim parts of New York Times articles. So it's pretty difficult for OpenAI to argue that they didn't copy anything when presented with that kind of evidence. Now, that case was filed almost a year ago and has since been consolidated with another case filed against OpenAI by the Daily News. And in response to the copyright claims against it, OpenAI has said that the use of its works to train ChatGPT is a clear transformative use that should qualify it ultimately as a fair use. And that's a key point in these cases that I'll touch on more in a minute. All right, moving on to talk about some music models and image generators. So there have been a few cases brought by music publishers and sound recording copyright owners against AI companies. And these I would also describe as some of the stronger cases, in part because what the plaintiffs have been able to demonstrate as far as the material that AI models generate. So in Concord v. Anthropic, a group of music publishers alleged that Anthropic copied and distributed plaintiffs' musical works, including lyrics, to develop Anthropic's generative AI chatbot called Claude. Now, the plaintiffs have shown when prompted, the models generate verbatim or near verbatim outputs of their copyrighted works. And then in Universal Music v. Suno and Universal Music v. Udio, a group of record labels alleged that the two music generators are liable for direct copyright infringement related to the unauthorized use of sound recordings to train their models. And the complaints offer evidence of potentially infringing outputs that mimic identifiable features of the plaintiff's works. And then just a couple image generator cases to mention. The first is Anderson v. Stability AI. That was actually one of the first cases brought in early 2023 by a group of visual artists, and it alleges copyright infringement for the use of plaintiffs' works in training the AI image generating platforms. Now, that case has been going on for almost 2 years now because there have been motions to dismiss that have been granted in part. There have been amended complaints, and the case involves four different defendants. So it's been slow going, but the court recently issued an order granting defendants motion to dismiss 1202 claims, those are the copyright management information claims, with prejudice, but denying the motions to dismiss the direct infringement claims. The other case I wanted to mention is Getty Images v. Stability AI. So back in early 2023, Getty alleged that Stability AI copied more than 12 million photographs from Getty Images collection, along with associated captions and metadata. Now, that case is interesting because they've shown what is arguably substantially similar output to Getty's photos, and those are the two photos you see here of the soccer players. But they've also shown not only substantial similarity, but distortion of Getty's watermarks. So if you see on the left is Getty's actual picture with their actual watermark, and then on the right there's sort of this distorted, mangled version of the watermark. That case has also been moving slowly due to ongoing discovery disputes. Just to quickly mention a few other cases that don't really fit into the groups that I've already mentioned because they involve different types of works. One is Doe v. GitHub. That involves programmer software used without authorization for training. There's also Thomson Reuters v. Ross, which involves copying and ingestion of Westlaw head notes. And there's actually going to be a hearing, I think in early 2025 in that case that is going to be interesting to follow because they could touch on some of the fair use issues. Next is Planner 5D v. Meta. That involves virtual objects and scenes used for interior design decoration. And then Vacker v. 11 Labs involving voice recordings used to train an AI voice generator. So a few takeaways that I would leave you with. In many of the cases, the claims for the removal or alteration of copyright management information are being dismissed because courts are holding that plaintiffs are failing to show an actual harm or have failed to demonstrate that the defendants knowingly removed the copyright management information and that the removal would result in infringement. That's sometimes known as the double scienter standard, and it's quite a high standard to meet. So, along with the derivative works claims that were dismissed in some of the cases in the early stage, which I mentioned earlier, that leaves only direct copyright infringement claims related to copying at the ingestion or training stage. Now, those direct infringement claims will be what these cases and perhaps the future of generative AI models are going to turn on. And the direct infringement claims will undoubtedly come down to whether the ingestion and reproduction of copyrighted works for the purposes of generative AI qualifies as fair use. Now, no court has ruled on that yet, but we're starting to see AI companies put forward arguments, like in the New York Times case, that what they are doing is transformative and there should qualify as fair use. In response to that, I would just note that, in wake of the Warhol v. Goldsmith Supreme Court decision, we now know that even if what these GAI companies are doing were to be found to qualify as transformative, that does not necessarily mean that it will be found to be fair use. There's other factors that go into that. One last thing I'll leave you with is that we've already seen many AI companies claim that the use of copyrighted works qualifies as fair use because it's just like this case from the past, or just like that case from the past where fair use was found. But I'd caution against relying on any past cases for too much support because, as the lawyers in the room know, fair use is a case-by-case, it's decided on a case-by-case basis. And there are many facts that distinguish these cases from the cases of the past. And really, generative AI technology has the potential, I think, to disrupt human creativity and markets for copyrighted works like we've never seen before. So I know that was a lot of information coming at you pretty fast. There's a lot more that could be said about these cases, but I'm just about out of time, so I'll stop there. I think we might have time for a question or two, or otherwise we could move into the next panel. Thank you. Oh, yes, please.
You have only the training and the ingestion. If they prove the training and the ingestion, then it would also be the outputs, right?
Well, if they proved, let's say they proved that their works were copied at the ingestion stage, it doesn't necessarily mean that anything that I think comes out of the other end is an infringement of their works. I think they'd still have to show substantial similarity. I mean, something.
Now, if you know that it's a master that's been ingested and you put it in the output as well, whatever percentage of it, it's still infringement.
The recording.
Yeah, especially for recording, like it's sampling. Like the courts ruled that if there's a master sample, if a master and a song are being, it's absolutely a sample and it needs to be licensed. So that same theory should be for this.
Well, I see. If you're the copyright owner and can prove that you own the works to everything that was trained, I guess I'm saying with a lot of these models, they could be pulling the input.
They are going to pull multiple inputs. That's the complication with figuring out how they're going to pay us. But if we can prove that they're infringing on our copyrights in the ingestion stage, then they're absolutely infringing on our copyrights in the output stage. That's how this could actually work out for people if we get paid on both sides.
Right. I guess what I'm saying is if they're drawing their input from, all kinds of different copyright owners, stuff from the public domain, what have you, then something that comes out the other end might just be public domain. So it's not necessarily that every output.
But you could verify what's used in the output.
Yes, I think it would make your case for infringing on the output side much stronger.
Okay, thank you.
Professor Simpson gets the final word.
Final word, sure.
Mark won't disagree that I mean, it seems to me that the copyright infringement is on the reproduction right, correct? They've taken your reproduction right without a license. But the output could be a fair use, arguably. So, I mean, I think that you win, I think, on the input, right? I think you should win on the input.
I think a lot of copyright owners now are focused entirely on the input because it gets trickier on the output side.
Right.
Kevin, thank you very much.
Yeah.
Great job. Around the world in 34 cases in 15 minutes. That was really impressive. Thank you, Kevin.